Good morning. I am calling to order the meeting of the Municipal Officers Election Board of City Metropolis. My name is Billy McDaniel, Mayor of City Metropolis. With me are Jan Adams, City Clerk, Mr. Charles Barfield, Senior Alderman of the City Metropolis. Under the law, the Mayor, City Clerk, and the Senior Council members comprise the Municipal Officers Election Board. First, we will call the roll.
Barfield.
Present.
The Mayor.
Yes.
And myself.
Election boards are formed and operated under the law of the state of Illinois, and each and every election board operates under local rules authorized by the law of the state of Illinois. This electoral board was formed and adopted rules some time ago. In today's proceeding, these rules will conduct a hearing regarding objections filed by Mr. Chuck Short to the candidacy of Mr. Samuel Stratemeyer for election to the office of Alderman, Ward 1 of the City of Metropolis. Both Mr. Short and Mr. Stratemeyer are represented by council. The electoral board is represented by council as well. In this case, the City of Metropolis Corporate Council, Mr. Abel, who normally advises us and able to serve as we have returned attorney Mark Clark to assist us. Mr. Clark will be handling certain matters of protocol and procedures during the hearing, subject to my direction. If and will necessary, Mr. Clark will also advise us on questions of law so that we might do the job before us in the best way we can. The agenda includes public opinion. Let me first emphasize that our business today is limited to what is set forth on the printed agenda. We will not be discussing today or any objections to any candidates that may have been filed, nor will we be discussing today any other business that might involve or affect the City of Metropolis. A record of these proceedings will make and kept by a court reporter, which I think we are recording. We ask at the first time anyone speaks to these proceedings that you will state your name, spell it, and provide who you are and what you're there for.
My name is Mark Clark, and my entry of appearance is in the file with my contact information. Members of the board, there have been two motions filed so far. One is a motion to disqualify an attorney, and another is a motion for sanctions. I have spoken to the attorneys about the procedure that we're going to follow today in an informal case management conference that was conducted by telephone yesterday pursuant to the rules of the electoral board. And the attorneys indicated to me at that time that they were in fact going to file additional motions, and I believe that all of the motions that are being contemplated to be filed have not yet been filed. They also indicated to me that they had substantial disagreements over what evidence was appropriate to be considered by the board during this hearing. The consensus reached was that the witnesses who had been subpoenaed should not be forced to sit in this room and wait for an uncertain period of time while we sort out what is and is not going to happen in the orderly disposition of the matters that are before the board. And the attorneys agreed that it would be most expedient if the witnesses were simply told they did not have to appear today, and they would be contacted on when they would have to appear. The general consensus was we were going to try our best this morning to resolve as many matters as possible with the attorneys and myself working together so that the hearing could proceed before the board efficiently and ensuring a fair hearing for both sides. And gentlemen, is that a fair summary of our discussion yesterday?
Yes, it is. Yes, it is. My name is Fred Turner, represent respondents.
Richard Kruger, represent Chuck Short.
Okay. So the first thing that I wanted to check this morning to briefly speak to the attorneys to be sure they had exchanged all of the information information that they were attaching to the motions that were put before the board. And there was a brief that has now been filed.
No, it has not. I've got the original copy to give to the clerk. I have previously delivered to both Premier and the Board's counsel. At the top that has the original exhibit sticker, but they'll have the original signature. Thank you.
This morning we spoke briefly to make sure that the papers had been exchanged, and noted the fact that the motion for sanctions recently filed, Mr. Turner had not yet had the opportunity to respond to the motion, and the suggestion was that it was going to be recommended that the board take under advisement or put off the hearing until Mr. Turner could respond. However, because of the nature of the motion, it might well be appropriate for the board to make clear exactly what the board feels it can and can't do, what it must and must not do, and most importantly, what is appropriate for other agencies to do. It is apparent from the face of the motion that the motion by Mr. Short alleges conduct by Mr. Stratemeyer. These are allegations of conduct that could constitute crimes under the state of Illinois, including felony offenses. This board is not a criminal investigation agency, and what to do about the fact that this matter has been filed in this file is a matter which may be, first and foremost, a simple reference or referral to the appropriate agencies, but that would be a matter that we would discuss ultimately when you retire to consider the motions. First, let me be sure that we understand where we are. With respect to the motion to disqualify, both sides have put before the board everything that they think is appropriate. With respect to the motion for sanctions, Mr. Stratemeyer has not yet had the opportunity to respond and wants to be sure that he has the responsibility or the ability to respond before the board considers the motion. Is that fair?
That's true.
Okay. Then I would respectfully suggest that the board retire to consider the deliberations on the motion for disqualification and how to address the motion for sanctions, fully understanding that Mr. Stratemeyer is going to get the opportunity to respond before you take up the merits of the motion. Okay. Now I have to confess that I'm new to this building, and I don't know whether the normal procedure is to exclude the folks and you all sit here, or whether it would be better for you all to retire to a nearby office to do this. With the number of people here, it might be better for you all to retire to an office, and I will be available to assist you in any way you think is appropriate.
In normal, we actually go into closed session for reasons of that. But I agree with you 100%. It's easier for the three of us to move than it is for y'all, and we're certainly open to that.
Okay. I just want to make sure
we
we're all on board with the procedure that we're following here. We're taking into account the logistics and the matters of convenience for the parties that are present. Okay.
Whatever works for
All right.
Consequence to back.
All right. Well, this will take a few minutes, so we'll be back as soon as we can. Okay. Thank you.
This election board, having considered the record and arguments raised, finds as follows. 1. That portions of Mr. Stratemeyer's motion pertaining to Attorney Rick Abel is moot, for the reason that Attorney Abel has recused himself in this case. 2. That portion of Mr. Stratemeyer's motion pertaining to Attorney Richard Kerber should be denied for the following reasons. A. The nature of Mr. Abel's status with Mr. Kerber's firm is more that of an independent contractor rather than an associate, employee, or partner. B. No substantive rulings were made by this election board electoral board, during the time Mr. Abel was the attorney of record in this case. Mr. Abel no longer has any involvement with the work of this electoral board in this case. And this electoral board is now represented by independent outside retained counsel who absolutely has no conflict in this case. C. The Municipal Officers Electoral Board is a separate entity from the City of Metropolis. C. Mr. Krieger's firm has no involvement whatsoever with the work of